Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings.
The vague and undisclosed expert testimony, I think, in part touches on this, but not entirely. So I'll let you talk about the other entirely part.
Yes, thank you, Judge. Then you'll get a break from me in a few minutes, I think.
I enjoy dialoguing with you, counsel. I appreciate it.
Well, good. I think we're going to have some time together over the next 6 months or so. Your Honor, this motion came after our hearing in January, and we're asking the court to limit what the state can produce with their experts here. I do have copies for the court, extra copies for the court. We had a specific request at the end of our motion. We called it Exhibit 1, and it went through all of the state's experts and basically described what we think the court should do with the state's experts. And so I wanted to provide that to the court.
I did see that.
Okay, good. Thank you. Let me get to my same page. I want to start, though, today with my presentation and my request with a little bit of history with this case. And as the other motions are, this motion, our motion for the court to exclude all of the state's experts as outlined in our exhibit, is based in Mr. Kohberger's rights to a fair trial, effective assistance of counsel, due process, and guaranteed by discovery rules and rules of evidence, and the court's own scheduling order.
It's rooted in Rule 16, which is kind of where the court looks at these issues.
Rule 16 it is, yes, Your Honor. This started with discovery requests very early on where we asked for expert information from the state. I'll skip forward to the court's scheduling order, which was very clear about what should happen and that we needed to have our expert disclosures in at a certain time. The state's date was December the 18th, and shortly after we received the state's expert disclosures, we filed a motion to compel. We wanted the rest of their disclosures. We had a dialogue in January about that, and the court asked me, why are you doing this? I'm going to make them abide by the rules, by the discovery rules. I really thought when we filed that motion, the state would say, oh, okay, and we'll just get you the information. Most of these are experts they've been working with all along. But that's not what the state chose to do. The state chose to say, nope, I'm going to dig in my heels, and we did plenty until the court said your job is not done.
Well, to be fair, and in the way I handle these issues with Rule 16 in the criminal context, the rule is not particularly broad about what is required. And the court has interpreted that rule fairly narrowly in other cases. I give the speech that I gave to you both in most cases where there are a lot of experts to encourage sharing beyond that which is required, because I think it helps both sides. And I think it helps the experts be better prepared to testify because counsel understands their testimony better. I think it allows for cross-examination better. And I think it creates just a more fulsome picture of things that way. And that's why I invited the state to supplement. And I also invited you to be likewise broad in your disclosures. Now, at the end of the day, I am bound by Rule 16. And so that is my guidepost.
Well, Your Honor, I believe Rule 16 references the Idaho Rules of Evidence. And I believe that the state's requirement is to provide at least the opinion that their expert is going to offer. And case law, it's the State versus Morin case, says that bare lists aren't good enough in this case. Your Honor, the state didn't immediately file and fix the issues that they had, but we filed our disclosures, and our disclosures weren't bare bones. They were exhaustive in method and analysis and opinion. And the state gained an advantage when it happened that way. The state then went from having their experts due on December 18th and really setting the bar. We have the burden of proof. This is what we're going to do. These are our experts, and this is how we're going to do it. They went from that place with their duty and their obligation to giving minimal, which were just lists other than a couple of their experts, and then receiving all of ours. And you can see in the next bit of pleadings that really shaped what they were going to do. When their rebuttals came due, they got an extension until February 17th, but that didn't see them fixing the problem that they had in large part. Some reports came in March 3rd, some March 14th. So the state has effectively given themselves months of additional time and the advantage of having our expert reports. And that just can't be when you're looking at fairness of trial, when you're looking at who has the burden of proof, when you're looking at due process. The state is to say, this is what we have, this is how we're going to prove this case, and for us to decide how to respond to that. And that got turned upside down with what the state has done here. They held back, gave us bare lists in large part, and then had the advantage of having all of our work, how we would anticipate we might rebut the state's evidence, and allowed them the advantage of deciding what to give us and when. It is extremely difficult when the state gives things just a piece at a time to us. It is extremely difficult when we have a deadline and we have plans, we have our experts, we have our schedules with our experts so that we can continue to prepare as we head towards trial. To have the state act in this fashion, to hold back and then to give things little bits later without even giving a full expert analysis in some cases. The court has the duty to ensure that we have a fair trial and that Mr. Kohberger's due process rights are adhered to. And the court should exercise its discretion and apply the rules and limit what the state is able to produce as far as their experts. I'm going to talk a little bit about the different experts here. They are outlined in Exhibit 1. I don't think I have to go through every single one. We tried to be pretty clear for the court if the court looks at that when considering our motion. But I do want to talk about a couple of them. And obviously, agent balance is the one I'm going to want to talk about. Your Honor has heard some things about this disclosure. I can't call it a report because it's a PowerPoint. I don't know what Agent Balance's conclusions are. And Agent Balance the PowerPoint obviously isn't going to be complete. PowerPoints aren't designed to be complete reports of what happened and what somebody thinks has happened. We've had several different disclosures now. They don't help much. On March 3rd, for the last time, we learned that Agent Balance acknowledges he analyzed the last 7 minutes of data on the phone, but we don't know what his opinion is about any of that.
To give an opinion about those last 7 minutes?
I'm sorry?
Doesn't that just mean he's not going to be allowed to give an opinion about those last 7 minutes? I mean, I can't force his expert to have an opinion, their expert to have an opinion.
You can't. And we're here asking you to limit what they can testify to by surprise once we get to jury trial. Agent Balance is worth further comment to the court. Agent Balance was co-located with investigators in this case from the very early days, just a couple of days after the killings took place. He is somebody that the prosecutors have had meetings with and have had ready access to throughout the course of the proceeding. So it's not like he's a stranger that they couldn't get his report from him. He has offered his PowerPoint with no analysis of these phone transactions, no analysis of the mapping that was done. And to understand that he conducts drive testing and he carries around a scanner when he does his drive testing, and that scanner will collect data about which towers are working at that given time. So you can get a lot more accurate information about where a device might be. The other way to look at what devices are doing is when you're looking at different cell towers and the phone transfers from one to the other as the phone might move around in a car. But the drive test data working with that shows you a place where there's a tower, all the places that there might be coverage. And then if the phone hands to the next tower, it'll show you that coverage too. So you can see limits, you can see gaps in where coverage is, and that helps you identify where a phone is more. Agent Balance hasn't analyzed all of the data he collected, nor has he told us what it means. So for Agent Balance, the court should preclude his testimony about the last 7 minutes, and the court should preclude the rest of his testimony, really. I think the state's initial disclosure was that he was going to talk about cell towers and how they work with cell phones. That might be fine. Anything else, they shouldn't. I want to tell you, though, while we're on the topic of that last 7 minutes, that it's more problematic.
That was part of the initial disclosure, correct?
The PowerPoint, I believe, was provided as a disclosure.
Did he testify for the grand jury?
No, nope. Officer Mowry, Detective Mowry testified before the grand jury. Agent Balance did not. So I don't have any of his testimony. But I want to tell you about the 7 minutes. And I want to tell you that those are problematic. When the phone's moving, when Bryan's phone's moving the last 7 minutes before it goes off the network, and you look at the locations of where the phone was, it places the phone in a place at 2:54.45 in the morning. And for Agent Balance to ignore that, there's a cascading impact on other bits of testimony that will come in. So it's imperative.
That's just impeachment.
Well, it's actually exculpatory to Mr. Kohberger, so it's worse than that. So
You're doing this in the frame of a motion related to the expert disclosure, and so his opinion is what his opinion is, and he's disclosed what he's disclosed. And let's just hypothetically say he can't opine about the last 7 minutes because he hasn't disclosed that, and I haven't gone through in enough detail to make that conclusion, right? Isn't that then just a matter of you putting on testimony from your expert about that 7 minutes and impeaching him about, you didn't even look at the last 7 minutes. You missed that. And what could that mean? Couldn't it mean as my expert, obviously your expert won't have testified by then, but impeach him essentially on his lack of diligence, as you would put it.
Well, I anticipate impeaching for the lack of diligence. Here's the fear, though. I don't know what he's going to say about those 7 minutes, so I want to impeach him about that. I want to impeach him about a whole lot more, too. But if I do, and he says, well, I did analyze it, actually, I hope the court's order stands and he's not allowed to talk about it.
You have to be careful about what doors you open. But
I agree. And when the court said that, it made me think of that. Going back to what I'm asking you to exclude, I'm asking you to exclude everything that wasn't contained, and there's no opinion, there's no analysis contained in that original PowerPoint. There's just PowerPoints with a few things on them that he won't be able to explain because
they did supplement and explain, at least in some detail, more about what each slide kind of means, as I understand it.
Well, Your Honor, that comes back to kind of where we started with the state waiting to see what we had. That's not how this works. In the adversarial system where the prosecution has the burden of proof, we can sit at the defense table and do nothing. I don't have to produce a thing. They have the burden always to prove the case. And what they've done is they've turned that upside down. They've essentially and figuratively shifted the burden by holding on to what they had, even though they have the duty, and said, show us yours first, and then we'll rebut your experts. And that's just not the way it works. And I think the court should look at their disclosure deadline, and they didn't go home from the January 23rd and 24th hearing when the court said your job's not done, I'm not going to allow things in that aren't disclosed. They didn't go home and say, we got to get this done now. They trickled things in bits at a time. And that is just not the way the system works. And that's in violation of Mr. Kohberger's rights. And we're asking the court to limit it. What they gave us on December 18th, that's what they get to talk about. There was no opinion in there, no real analysis in there. And that's our position. And that's the way to bring it back and keep the burden at the table it should be and protect the due process rights and the right to a fair trial at the table it should be. In our filing, I won't read it all to you. We had a lot to say about that with Agent Balance.
Search warrant application include the analysis of the cell teller information?
Did the search warrant application include the analysis? Let me think what the search warrant application said first.
That large, omnibus document that they used,
Oh, Exhibit 1 that was attached to all of them.
attributed to, if not the signatory, but the FBI CAS team.
Well, we're talking about a couple of different parts of the affidavit. There was the factual part of the affidavit that Moscow Police Department, various members of the police agency used it, the same affidavit or a couple different versions of that same affidavit. There was a part that I don't think Nick Balance ever signed it. I think he
My point
dictated
is
it.
were you on notice of what the state's version through the CAS team of what that data showed?
If I look at the affidavits, there are a few things, yes, that I would be on notice for. They're not attributed to Nick Balance, but there are a few things. Those are the problem areas, and I don't want to open doors that I shouldn't. I mean, I either need his analysis if I'm going to open the door, or he doesn't get to talk about it. And let me tell you what I mean.
About the adversarial part, I also looked then in that case at what information you did have about what the state's case was. And so, it seemed to me that in general that cell analysis was part of that, because part of the motion on your part was the missing 7 minutes.
That definitely was part of the motion, and now for the first time, I know he actually analyzed it. What that affidavit, those two affidavits, I would tell you about 3 parts that could be attributed to any cell analysis, and then I'm going to tell you the problems with those 3 parts too. The first is that the phone went off at 2:47 a.m., which it did not. It did not. That's untrue. The other is that the phone was traveling towards Moscow when it went off, and that's absolutely untrue as well.
I recall the 47 said it was traveling southwest.
Well, that's what we say. That's what the record shows.
That's what the application said.
The application said that the phone stopped reporting to the network at 2:47 a.m.
Traveling southwest at the time, southwest of Pullman.
That's not when the phone stopped reporting.
I realize that, but it's not like they were representing that it was at 2:47, halfway to Moscow or traveling to Moscow. It said it was southwest of Pullman, which, as I understand, the 2:52, 54,
70.
7 minutes later indicates it was traveling southwest to Pullman.
None of the search warrant affidavits have anything about 2:54. It was.
I understand that. My point is the time was wrong, but the point that the direction of travel is the same.
There are paragraphs in the affidavit that talk about the phone traveling towards Moscow. There are slides in Agent Balance's PowerPoint that have an arrow, and that's not true.
Well, there is a in the search warrant affidavit, and I think as part of the PowerPoints, a I don't remember the language it used, but basically the believed route of travel or something like that. In other words, their opinion of what the travel route was. And so that was disclosed, what that alleged travel route was.
Cell phone records would indicate something different than they said. So and I see what the court's doing. The court's saying, okay, you have this PowerPoint. What else were you on notice of? I'm on notice of things that the records contradict, the records being the AT&T records that we received from the state. And those records contradict those things in the affidavit. I'm also on notice.
Allow for supplementation of expert disclosures to correct errors, to provide new information, to make them fuller. I mean, the rules allow for that.
That's not what they've done.
I understand that's what you're saying. That's what they haven't done.
That's not what they've done, Your Honor. And
that's why I'm looking at what did they actually say beforehand, because I think part of it is a notice issue to you.
Well, I'm on notice of things that the records don't support. I'm on notice of a PowerPoint that doesn't have any analysis or opinion in it. So those are the things that I'm on notice for with regard to Agent Balance testifying. So I'd ask the court to not allow him to testify beyond the December 18th very limited disclosure. We have the disclosures that still have some vague language in them, and we talked about this back in January, where it's imperative to not let people offer opinions based on this vague language that they can change their opinions. That happened a lot with lab people. There were some additional disclosures with lab people bringing in CODIS. That came in the...
That's not an opinion, first of all. It is an explanation of why they didn't submit evidence to CODIS. I'm not seeing how that's an opinion. That's just a statement of what the facts are.
Your Honor,
it's not expert testimony. That's, here's our policy, here's when we submit stuff to CODIS, and here's when we don't. And this has been raised as an issue. Why didn't this get sent to CODIS? And this is why. I don't see that as an expert disclosure issue. That's purely a factual issue.
So the protocol allows the individual, a certain analyst, to make that decision. That's what the protocol says. The why of that decision has been something that we learned about for the first time in the February 17th disclosure. That was curious.
My point is, I don't really view that as expert testimony. That is simply the underlying factual happenings. It's like, why did you then make a phone call to this person? Well, because. I mean, it doesn't make it an expert opinion. In my expert opinion, I thought it'd be good to call this person. These were fact people on the ground making decisions about the investigation. Now, in today's world, and as the state pointed out, there's an over-disclosure of fact witnesses as potential experts so that they're not caught in the situation the lawyer was with the drug recognition expert with the state police when it was determined, well, he was offering an expert opinion about something in that regard. And so you get a lot of fact people disclosed in expert disclosures, but I'm not sure how, because there was a lot of briefing back and forth on that, how the decision whether or not to send the stair rail DNA to CODIS is an expert testimony. It's just basically lab protocols.
I think as long as it doesn't tread into an expert opinion about that, we can...
What would that be?
I don't know. I haven't read one. I don't know. I mean, if they're having some opinion about what those spots on the handrail and the wall look like, I guess.
Well, I mean, I wouldn't expect to see at this point an opinion that, it was the DNA of Y person, right? Unless there's been newly discovered evidence.
Well, I don't have any of that today, but I understand there's more for me to pick up, but I don't know what it relates to. With regard to the lab personnel, I think the best thing to do is keep them to their lab reports and the disclosures that are explanation but not opinion. The concern that the defense has with a lot of the lab personnel is some of the loose language about the ability to testify about other things. And as long as they're kept to those opinions, I think we're informed on most of those. Again, not going through everyone. I do want to talk about Dawson, though. Dawson was an expert that was disclosed in rebuttal, but there was nothing to rebut. He's an expert that talks about toxicology, and we are.
Didn't you produce an expert who said that that there wasn't it would have required two people to commit the crime?
Your Honor, we have produced an expert that believes that it's likely that there were two people, two weapons. That
Dawson
doesn't.
testimony about the degree of intoxication goes to the what I'm assuming was, given that degree of intoxication, the ability to fight back. In rebuttal to your experts, as I understand it.
I think that's what the state says. I don't think that's proper rebuttal. Well, because we didn't talk about intoxication, because the state's medical examiner talks about defensive wounds anyway. So this would seem to be contradictory with other testimony that they intend to put on. We are not contesting the intoxication level of any of the deceased.
I understand your argument.
Thank you. Again, Your Honor, I think that our exhibit stands on its own, and I just wanted to highlight a few of these. I do want to talk about the cell phone and third-party data, digital data disclosures. We have a little bit more in the way of opinion now, but not full opinion. And the state said that we didn't give them enough to rebut, and that's because we don't know what opinions their experts are going to come up with. They still haven't disclosed full opinions, and so we want to highlight that for the court.
What haven't they disclosed?
Well, in the Barnharts, they said they were going to talk about habit evidence. I don't know what that is. The most of the rest, there were three, Mowry, Urig, and Tanzola, that looked at the digital data and the cell phone data. I don't have any idea what they're going to talk about, except Urig is going to say that there's no connection between Mr. Kohberger and the others. That's the only actual opinion that's been disclosed in that. The last one I wanted to highlight for the court is the Douglas, Special Agent Douglas's testimony. That seems to have shifted a bit from he's going to talk about bank records and debit purchases, and it's become bigger without any opinion. I don't know what his opinion about anything will be. That needs to be limited. I think he can come in and talk
through the financial records and say, this shows a transaction with Mr. Kohberger's credit card to purchase a Amazon gift card, and that this Amazon gift card was used to purchase a knife.
If he can say all of those things, I think that his ability to talk about receiving the bank record and looking at it and saw a purchase history, I think that's fine. But to provide an opinion about what that means, that's not disclosed. Well, Your Honor, I don't want to wait to find out. I'm asking the court to.
My point is I'm not in a position to exclude their testimony because they haven't shown me that they're offering something beyond what they've disclosed.
Your Honor, I respectfully believe that the court is in a position to limit what hasn't been disclosed and would ask the court to do so. The state has had a lot of time to provide these disclosures to us, and what they've done is taken the advantage of having our disclosures and bit by bit giving them to us. This is challenging to prepare a case of this magnitude in any event, And to have things piecemealed out just delays our preparation time. And it's also in violation of the discovery rules. It's in violation of the court's order, and it violates Mr. Kohberger's rights to a fair trial, effective assistance of counsel, and due process. And it is within the court's realm to say, you're not going to do any more after this particular date. There's no opinion written down for certain people. It can't be offered now. And we think that's what the court should do. If we wait until we take it as it comes during trial, that's better than nothing, but it's very difficult to prepare, and it eats into what limited time we have to prepare, and it will waste a lot of jury time to have to take these things up again and again and again. The state knew what their duties were. They've done this for a long time, and they chose this course of action, and the court should limit what they can do and issue an order limiting their experts.
Defendant makes a lot of assumptions about what has occurred. However, I can tell you the state didn't wait to see what the defendant was going to disclose first. That would be an incredibly risky game for us to play. And that's not what happened. We know what happened. As laid out in the state's response, the state filed our initial disclosures on December 18th, 2024, disclosing 25 experts for the guilt phase. And then at our last hearing on January 23rd, the court addressed this issue. And Your Honor stated and issued a word of caution, instructing the parties that the disclosure should cover over-disclose. We should really go back to our experts, lay out, and you talked about the amount of work that this would take well in advance of trial to go through everything that they intend to testify to and put that into a disclosure. And that it doesn't go as far as the civil rules, but that you didn't want to have these issues coming up at trial. You were very clear in that you directed to the state that our work was not done. We took that to heart. You did not set a specific deadline, but instead instructed both the parties that supplements would be reasonably allowed. In response, we did immediately go back. We went back to all of our 25 experts and asked them to review their testimony. We had to have several meetings to discuss what their testimony was going to be, and they supplemented their disclosures. On March 3rd and March 14th, the state filed the supplemental expert disclosures. I submit to you that the state has complied with Rule 16. We have a continuing duty to supplement. The defendant has filed expert disclosures past their deadline. The state has allowed that. We are trying to be reasonable in this. And in fact, in that stipulation to allow them more time to disclose, we stated, it serves the interest of the parties and the court for there to be reasonable flexibility to facilitate the development and exchange of relevant information to assist the trial jury. That's where we're at, and that's what we're asking for. Thank you.
If we were talking about one expert of the states, that might make sense. We're talking about wholesale not complying with Rule 16 and with the rules of evidence regarding experts. When we realized that the state hadn't complied with the rule and provided us very little in the way of understanding how their experts would frame the issues in the case, we sought an extension to prevent the state from having our work first so that we could try to respond to what their expert disclosures were with our experts. That wasn't something that was given to us. That was denied, so we filed our expert reports. For us to have a couple of experts that came later when the state has done their job as they've done their job, that is really a hollow way to say they did it so we can too. The state did not comply with Rule 16 or with the court's order, and the court should limit what they're allowed to produce at trial.
All right, I'll take that matter under advisement. I did invite the parties to supplement. It takes time to supplement. I'll look through to see if there's any significant new additions. Well, first, I'll look to see if what is given is adequate. Secondly, if there's anything that was provided that wasn't shaping and as I've said, making more fulsome, making more whole, making more clear what opinions there are. The defense I know was given, and as I explained, the defense has the ability to supplement as well in response to the state's supplementation. Part of the reason the discovery order is as early as it is to the trial date in this case is because in my experience in cases of this, we have this problem always of ongoing continual supplementation and disclosure. And so I wanted to accommodate that within the time frame within the several weeks to months in advance of trial. And so I'll look at it and I'll get you an opinion.